In the late 1970s, the Medicare system was still very new. One of its features is that doctors are paid a scheduled fee for every service delivered to a patient. Now, obviously, this process comes with some risks because doctors could just perform heaps of unnecessary services in order to get more money. This is called overservicing. The legislation created a system for dealing with overservicing. If the relevant officer made a decision that a doctor had been overservicing, the doctor could appeal that decision to a review tribunal, and the review tribunal would consider the request for the review. In this case, a Dr. Tiong, a radiologist, was subject to a finding that she had been overservicing. That decision was appealed to the review tribunal. However, once it was there, the review tribunal amended the grounds for review and then considered the case on the basis of those amended grounds for review. They found that overservicing had taken place. The full federal court considered whether the tribunal had committed an error of law by amending the grounds for review. There were two ways to look at it. On the one hand, the legislation gave the tribunal quite broad powers to determine its own procedures. On the other hand, the law was set up to enable the tribunal to consider a request for review, which impliedly means considering the grounds for review that were actually put forward by the person seeking review. The court was very clear in its opinion. Justice Davies said that the relevant section is directed not to applicants but to the review tribunal and specifies how the review tribunal is to go about its task. The provision binds the tribunal. The review tribunal must review the determination in accordance with the request for review, and in doing so is to consider the matters to which the determination relates, having regards to the grounds set out in the request, the documents forwarded with the request, and any addresses made to the tribunal during the proceedings on the review. There is no ambiguity in this provision. An amendment to the grounds of review specified in the request is outside the function of the tribunal. From this case, we learn that if the statute specifies procedures for the decision maker must follow those procedures, or they lack the power to make the decision.